All right, Simone, thank you. A federal judge has formally ruled that several Arkansas laws tightening the state's ballot initiative process are unconstitutional. And the decision has sparked reaction from the lawmakers who called for those laws. Just 3 days before the deadline to submit petitions for this year, a federal judge said restrictions like requiring potential signers to present a photo ID or read the ballot titles all cause unnecessary burdens and violates the First Amendment. State Republican lawmakers who recently took aim at the ballot process say the laws they passed add more security to the system. Tonight, THV11's Carter Thweed has reaction from some of those lawmakers who say piling on requirements is part of checks and balances.
Friday marks Arkansas's deadline when organizers who collect enough signatures can get a constitutional amendment on the November ballot. But lawmakers like State Senator Kim Hammer say that process isn't secure.
You have nearly 1,000 people that called Secretary of State's office wanting to have their names removed off a petition. You've got people coming from out of state that are declaring that their residency is at a motel when in reality they live in other parts of the country.
That concern is why Hammer sponsored laws to require petitioners read a ballot title aloud before someone signs and recite a scripted message about petition fraud. Other laws require petitioners to check a signer's photo ID.
We just want to make sure that our election process remains the #1 in the nation for election integrity and security, even with the petition ballots.
But earlier this week, a federal judge ruled several of those laws are unconstitutional. Ballot question supporters claim the new laws made the process impossible. The judge ruled in their favor and against Secretary of State Cole Jester.
That ruling will make it much more difficult for us to make sure our elections have integrity in this space. Things like photo ID in the petition gathering process, making sure that people read what they sign, that's just basic common sense.
The ruling comes as Hammer runs for Secretary of State, a role that oversees the petition process. Meanwhile, local organizers are collecting signatures for a ballot initiative aimed at protecting the process and blocking future laws like Hammer's.
We're appealing the whole order, and we're going to take it to the 8th Circuit Court of Appeals, which meets in St. Louis, where we will make our case that this is not against the First Amendment, but it is critical for our election security.
I think eventually we're going to find that they are deemed constitutional.
For THV11 News, I'm Carter Thweet.
Carter, thanks. Ballot question committees proposing new amendments will need more than 91,000 valid signatures, and Secretary Jester's office will be the ones who check if they're valid. If they fall short but still come up with about 68,000, they can get 30 more days to close the gap.